Live.
Well, hello everybody, and welcome to the latest Practico podcast. Podcast which used to be called Cost Chat Between Friends. We're still friends, but we've updated the name of the broadcast. Very pleased to welcome today Alex Hutton KC of Hailsham Chambers, who's definitely an old friend of both Practico and me personally. We used to share a room. And together with Alex, of course, there will be the usual suspects of me, Jeremy Morgan, retired Cost Silk, and Andy Ellis, Managing Director of Practico. Alex, I don't think does need an introduction. I'll simply say he's from Hailsham Chambers and one of the top guys in costs. I'm not going to run through all the things we're going to touch on today. It's going to be the usual mix of discussion of quite important and interesting developments, and a bit of signposting of things that you need to be aware of just in case you missed them somehow while you're on holiday on the beach or something like that. The first thing we're going to talk about, though, and this is going to be brief, I assure you, is the extension of fixed recoverable costs, which took effect on the 1st of October 2023 and will not affect major commercial litigation, but Alex will explain very briefly what might be of interest to commercial practitioners.
Yeah, thank you very much, Jeremy. And so the extension of the fixed recoverable costs regime was a goal of Sir Rupert Jackson ever since his report in 2010, and he was then retasked with doing it in 2017 because it had never been brought in. The only things that are really covered by fixed recoverable costs at the moment are personal injury, low-value personal injury claims, road traffic, disease, and employer's liability. But it now is going to apply to all cases up to £100,000 in damages, with a few but very, very limited exceptions. And it is important to recognise the transitional provisions in relation to it. It applies for all non-personal injury claims to where proceedings are issued on or after the 1st of October 2023. So if you issue your proceedings today and your claim is for £100,000 or less, you are covered in relation to a non-personal injury claim. The personal injury claims have a much more flexible regime as to when it applies, and there'll be a long lag for those, but not for non-personal injury cases. And essentially, it introduces a new track, which is called the intermediate track, between £25,000 and £100,000 in damages. And it then has within that intermediate track a number of bands that you can fit into depending on your claim, how complex it is and how much it is for. And you end up having to look at a horribly complicated table to see if your case is settled, how much you get, basically. You will get disbursements on top. They don't fix the disbursements, but the profit costs are all fixed and counsel's fees are all fixed. It's pretty miserable for certain things. If you have interlocutory hearings, for instance, you get very little indeed. Obviously, I'm sure most people listening to this podcast, don't routinely do cases for £100,000 or less, but some of you may come across it at some stages. It may be relevant for recovery of your fees, for instance, those kinds of things. It provides certainty. Obviously, you know what the answer is as to what your costs are. You don't have to go off and have a detailed assessment afterwards. So it gets rid of the detailed assessment process apart from the disbursements. But it is not generous, and you need to bear it in mind if you've got any claim that's going to fit into that category. You can get out of it if it's going to last longer than 3 days as the trial, whether you've got more than two experts, etc. But in general, your case will be caught by the fixed recoverable costs regime. Of course, it is fixed recoverable costs, so it's not fixing costs between you and your client. It's only fixing the costs that you can recover from the other side. You can charge what you like with your client as long as you obviously agree it, but it does open the risk of greater shortfalls being recovered from the client because you can't get so much off the other side. In general, it's regarded as likely to reduce the amount you're going to recover, and therefore it opens up those possibilities, which it's an already a growing field, as to disputes between solicitor and client, because the client is going to end up paying for shortfalls on it.
Thanks very much, Alex. What I particularly loved about this was there has already been a consultation on further amendments to the new fixed cost regime. But if that's the bad news, the good news is the consultation was already closed in September. So don't worry about writing in.
The answer as to why that happened was that there were various applications for judicial review, including from the Bar Council, from the Association of Personal Injury Lawyers, and various others. And so they thought, oh my word, we better do a new consultation in order to head this off. So that's what they've done.
Brilliant. We haven't bored you with the detail because it really is quite complex if you get into the detail. We didn't think it would be relevant to most people. If any of you do find that you do need to know rather more about it, both in terms of explanation and also commentary on how it's going to work, at risk of upsetting Alex, can I refer you to the podcast by Andrew Hogan and Paul Hughes of King's Chambers, which is well worth looking at. There's an hour in which Andrew Hogan, who is another friend of Practico, I hasten to add, discuss the implications of these things. It's well worth listening to because it's really very informative.
Having lost in the Court of Appeal recently to Andrew Hogan, I can certainly extol his virtues.
And Andrew ends up by saying, well, what do we make of it all? 2 years of pain. So I suspect he's right about that.
Yeah.
Anyway, let's move on to something which is more likely to be of immediate relevance to most people watching, those who are interested in third-party funding. We have already in the past discussed, shortly after the judgment, the decision of the Supreme Court in PACCAR. Now it's time to sort of sit back and see how that's bedded in, and we're going to invite Alex to do that. You will find on the internet lots and lots of articles about it, many of which are quite informative. The best article title I came across was "The Truck Stops Here" from Enyo Law. So I'll leave Alex to explain why that's relevant to this particular decision.
Yeah, so thank you. So just a brief recap of what was decided, and I can tell you the date. It was the 26th of July, 2023, because I was about to go on holiday, and all hell broke loose when the decision came out, and I was inundated with things, and I was going, oh, I'm trying to go on holiday. But anyway, like many cost counsel, I think we had various conferences on Zoom from our places in Italy or Spain or wherever anyone was for their holidays. So the Supreme Court decided by a 4-to-1 majority in a case that originated in the Competition Appeal Tribunal, or CAT, that a traditional third-party funding arrangement in which the fund receives a percentage of the damages in return for funding the litigation, that traditional third-party funding arrangement was in fact a damages-based agreement within the relevant section 58AA of the Courts and Legal Services Act, and it therefore was covered by the DBA regulations as well. In that case, which was, I said, was a CAT case, the decision was fatal in the sense that it was an opt-out proceedings CAT case, where obviously you are everyone in the class is included unless they specifically opt out. And because of the concern that DBAs would give rise to huge amounts of fees for the lawyers, disproportionate fees, they are not allowed in opt-out CAT proceedings. They are unenforceable under the Competition Act. And so it was fatal there. The basis of the decision was that what funders are providing in terms of funding amounted to claims management services, which was very widely defined in the relevant legislation. The Court of Appeal had adopted a very practical, pragmatic approach to say, well, funding litigation is not truly a claims management services because it's nothing to do with managing the claim, but the Supreme Court, or at least 4 of them in their wisdom, decided that it was a claims management service. Therefore, the agreement in that case was unenforceable and would be in any opt-out proceedings in the CAT. But in relation to any other proceedings, not only opt-in claims in the CAT, but also any High Court litigation, it means that a traditional third-party funding agreement must comply with the legislative requirements of the Act and the DBA regulations. Otherwise, according to the Act, it is unenforceable. So that's the background. The difficulty with it is that, you know, if you're not in opt-out proceedings in the CAT, and therefore you could, in theory, comply with the DBA regulations or change your third-party funding agreement to comply, it's not actually very easy at all to comply, mainly because it is perfectly plain, although unfortunately the Supreme Court didn't buy this, it's perfectly plain that the whole regime was not designed to cover third-party funding. It was designed to cover lawyers. And so you have to comply, for instance, with Regs 3 and 4. Reg 3 isn't too difficult. It's just, you've just got to specify the case, the circumstances in which the legal representative, and it uses those words. So the third party funder in this context is defined as a legal representative, which shows just what an Alice in Wonderland world we're in. You have to define the circumstances in which they get paid, and you have to give the reasons for why the percentage payment, and it usually is a percentage payment, is fixed at the level it is. But it's Regulation 4 that provides the real difficulties, because Regulation 4 says that the DBA must state that the payment due to the legal representative, in this case the funder, must be net of any costs recovered from the other side, and or net of any disbursements recovered from the other side. Now, the difficulty in this context is that you'll often have in this situation a solicitor's DBA already where they have complied with that provision, so their payment is net of any costs or disbursements recovered from the other side. So how do you then make that work in the context of a funder where you've already netted off that amount? You can't net off the same amount again. It doesn't make any sense. So that is a real problem, and I don't know whether anyone has found a way around that. Clearly, there aren't decisions about that as yet. But there are, it is very live immediately, but there was a hearing in the CAT this morning in an opt-out case involving a third-party funding agreement for a percentage of the damages, where the very arguments were being raised as to what amounts to a DBA in these contexts. And you know, one of the issues that is being litigated is that the obvious way to deal with this is to change it from a percentage of the damages going to the funder to a multiple of their commitment. And traditionally, third-party funders often agreed an alternative, which is the higher. I either get 3 times what I put in, or I get 30% of the damages, or whatever it might be. The obvious way to change your agreement is just to cut out the 30% of the damages and say, I'll get 3 times my commitment. But the potential problem with that, which seems a neat solution, is that the reality is that 3 times your commitment is clearly coming from the damages, because that's the only fund that you have. The agreement will often say it's from the damages, and will often cap the amount that is paid to the funder by the amount of the damages, so that the poor client doesn't end up having to pay more to the funder than they've received in terms of damages. But that potentially raises the issue, well, if you're capping it by the amount of the damages, it is therefore determined by reference to the amount of the damages. It is therefore a DBA and falls into the same problem that a percentage does. Now, that's a very unattractive argument, because clearly if you have a cap on the client's liability, that's a consumer protection provision. It's a good thing. So it would perhaps be odd if the courts or the CAT decided that thereby brought it into the DBA regime. But that argument is out there, has been argued this morning judgment reserved, will no doubt be argued in a number of other cases. It's primarily being driven at the moment in the CAT because there are live cases, and there is a process in the CAT where the court has to approve the funding arrangements as part of certifying the claim going forward. And the advantage in the CAT is that you can then have a ruling, well, in fact, this isn't compliant, but if you did X, Y, and Z, it would be compliant, and then you do X, Y, and Z. Whereas in the general litigation, these things often arise after the event, after the costs order, when the relevant authorities suggest it's too late to change your funding agreement after the costs order with any effect in terms of the other side. So you're stuffed on it. So that seems to be the current state of play in relation to it. It does provide a serious threat to litigation funding in this case, in this country. It is possible that the government will step in and do something about it. They've already issued the Department of Business has already issued a statement about it, saying it's looking carefully at it. And I know I've heard that there's a lot of lobbying going on in the government by Harbour Litigation and various other major funders trying to change the position, because litigation funding has been very widely used in this country and has driven a lot of litigation. That the angle I understand that's being pushed is that it's the Consumer Rights Act, which gave rise to these opt-in and opt-out proceedings in the Competition Appeal Tribunal, is effectively being completely undermined by this, because these cases just simply cannot be brought without third-party funding. And if that becomes impossible, then the regime which came in 2015 is effectively rendered toothless. So that's a brief summary of where we are.
I was interested, Alex, to see that the statement from the government in response to the decision in PACCAR was issued by the Department of Business, as you say, and not by the Department of Justice, for example, which is where you thought it might have fallen more naturally. I wonder if and then I wonder whether there's presumably a lot of business also saying, well, this is a dreadful, thing, third-party funding. Here we are getting on with our business in a nice little way, making some agreements between truckers. I shouldn't say things like that, but it's actually inhibiting our business and incurring lots of unnecessary costs in lefty lawyers bringing hopeless claims against us for carrying on our business in a perfectly normal way. That would perhaps be an argument that appealed to this government. I don't know which way the Department of Trade would jump.
No, I agree. I mean, one of the slightly galling things about it is that it's been plain ever since the regime came in, the DBA regime came in 2013, that the legislation was incredibly badly drafted. And there's been all sorts of lobbying going on to government to change that legislation. Indeed, Nick Bacon and Professor Rachel Mulheron produced a very helpful redraft of the DBA regulations. Rachel Mulheron, to give her credit, because she was credited for this in the Supreme Court, had spotted this very point about claims management services and third-party funders being caught by the DBA regime by a sidewind, not deliberately, and her draft with Nick's draft would have dealt with that specifically. But the government steadfastly ignored all that for 10 years, and then it ends up in this disastrous decision for third-party funders. So does that tell you that the government's not going to do anything? I don't know. I agree with you. The angle to be taken with a government clearly is it in the government's interest to get this in? I mean, people said when Jackson came out, they said, the government will never do anything about it. They'll never legislate. They're not interested in that. They were wrong, and they were wrong because the government bought the idea that it was going to cut the government's bill. They wouldn't have to pay success fees and ATE premiums, etc., and the whole cost would come down, which was a benefit to the taxpayer and to the government. And so that's the angle one's got to take. As I understand it, the angle's been taken, well, look, you brought in this consumer rights provisions, which are controversial. Opt-out proceedings are, you say, Jeremy, that they're controversial because, we're all, I suspect, in the MasterCard opt-out things. Not only perhaps we used a MasterCard, but it doesn't just cover those who've used a MasterCard. It covers anyone who's made any transaction in Britain between, you know, a 10-year period, because the argument is that the fees that MasterCard are charging are too high. But those fees are not, you don't have to pay more if you use your MasterCard. So those fees are factored into all the prices of things that we pay in shops, because they've got to pay these things. So we're all in that category. We're all, you know, unknowingly, you know, possibly going to get a letter in at some point saying, you know, you've got £75 or whatever it is as a result of being in this action that you had no idea you were in. So it is a controversial provision, but nevertheless, it was this government that brought it in. It is a significant provision. There are a lot of opt-out claims being brought in the Competition Appeal Tribunal, and it is felt that it is giving the consumer a right against these huge organizations, you know, Google, MasterCard, etc., who are otherwise unaccountable for what they do. And so, you know, from that angle, it's arguable the government will be interested in it, but it doesn't have the immediate advantage of cutting their bill, which I think is what they really like in terms of changing things. So I think, you know, we'll have to watch this space. You know, I wouldn't hold your breath about changes, but we'll have to see.
Well, thanks, Alex. And what you said earlier about the remuneration of third-party funders by reference to a multiple of invested capital is particularly interesting, and actually answers a question we had from one of the solicitors who regularly follows our podcasts, who'd asked about an article in the Law Society's Gazette by Jim Diamond, a cost lawyer, painting a very gloomy picture for the profession and for third-party funding as a result of the decision in PACCAR. And his question was, well, Jim Diamond includes those situations where the payment is by reference to a multiple on invested capital. How can that be? And Alex has given us a clear statement of the argument, and that's all it is at present. It's an argument which is being run. Thanks very much for that. The next thing we wanted to possibly touch on, but I'm not sure if there's anything very much to say, guideline hourly rates. Court of Appeal a little while ago, particularly Lord Justice Males, made some strong comments about not exceeding guideline hourly rates on summary assessment. Is there anything to add to that, or is that really where we are now?
Just a little. So the guideline hourly rates came in after a 10-year hiatus in October 2021. So there'd been no updated guideline hourly rates. And as you say, Jeremy, Lord Justice Males in Samsung on Electronics, and also Athena Capital with Lord Justice Burrs as well, Lord Justice Burr's statement is interesting because he said that the guideline hourly rates were based on evidence from the business and property courts themselves. And therefore, the London 1 rate, which is restricted to very heavy commercial and corporate work by centrally based London firms, that London 1 rate was evidenced, in his view, as to what very heavy commercial cases should be costing. And he applied that in the Court of Appeal to the principle, well, you've got to show a persuasive reason as to why you should get any more than guideline hourly rates. And in that case, they've done what many people do. Well, this is a very heavy case, you know, very difficult commercial case. And that wasn't good enough. You've got to provide specifics. So there have been some decisions since. There's a decision by Mrs. Justice Cockerell in a case called Infrastructure Services Luxembourg against the King of Spain earlier this year, in which the rates claimed were 1,170 for a grade A, whereas the guideline hourly rates are 512, I think. So pretty much over double, in fact. And Mrs. Justice Cockerell wasn't having any of it. She said basically another case where you would just simply get the guideline hourly rates. What is interesting is the cost judges aren't really following suit. So the cost judges have always felt, well, you know, I do costs, I know costs, you know, guidelines are, you know, pretty much irrelevant for me. I know the answer. And these High Court judges are just, you know, they're just swallowing the guidelines. We don't have to. And so there is a, you know, you will do a lot better on detailed assessment in front of a cost judge than you will do at the moment on summary assessment in front of a High Court or Court of Appeal judge. And I suppose that will continue until somebody successfully appeals the cost judge and says, well, you should have stuck more closely to guideline hourly rates. But it is another factor which is, pushing people towards Solicitors Act assessments on the basis that the shortfall that the client is getting is much larger if you're literally applying guideline hourly rates, even in big cases. It's part of a theme, I suppose, of today, in a way, that if you're recovering less off the other side, you're going to be unhappy about it as a client often, and you're going to want to challenge.
I mean, just a question on that. I mean, I wonder if you're talking about the big disparities and the very big numbers, whether those challenges would fly on the basis that usually they're being applied to people who satisfy all the criteria of being a sophisticated client, and they should know what they're signing up to, and they know about, the lawyers they select and why they select them. But it clearly gives, if you're talking about giving rounded, informed advice on recovery, it seems to bolster the difficulties that some solicitors have explaining, well, look, we charge this. Of course, if you win, good news, but you'll get back something. But it is a contribution. It's not, well, that's how it is.
No, absolutely. I agree completely. When you're talking about halving the rates, because 1,170 sounds a lot, but it's not out of the way. In terms of commercial litigators, well, you're not going to get anything like that. You might, if you're in front of a cost judge, get between 600 and 700, but in front of the Court of Appeal or the High Court judge, you're going to be lucky to get any more than 512. So you're losing half just on the hourly rate, which is a big thing to swallow. So it does behove solicitors to be very careful in the advice they give at the outset. I completely agree.
Do I remember correctly? Was there some suggestion in the way that the guidance was worded when it was finally issued that it may have been, the MR's intention to get this to infiltrate full inter partes costs and not just summary assessment a little bit more, these guidelines?
Yeah,
I seem to remember there was something along those lines.
Yeah, no, there is something along those lines, that. There isn't really a logic. I mean, people say, oh, well, it's just to do with summary assessment. It shouldn't be applied on detailed assessment. Never really understood that argument, I have to say. I mean, I just in the old days, you used to when, we remember these days, you used to get care and conduct, which varied as to what you were doing. So the solicitor sitting behind counsel would get a lower hourly rate than the solicitor actually drafting things. That's all gone, long gone. You get a flat hourly rate for everything. So why should there be a difference between your summary assessment rate and your detailed assessment rate?
Yeah, no, I agree. And also, I think recency seems to trump lots of things. It seems to me that they finally got something that's recent. If you're not going to use it, why have it?
Yeah.
So yes, it is becoming, in our experience, closer to a tariff.
Yes, I agree.
Yeah. Thank you.
Well, then it'll behove them to keep it up to date properly, won't it?
Yes.
Well,
I know they say they're going to, but
it's 2 years on already, isn't it? October 2021, we're October 2023. And, it's a common bugbear in these things that these things are never uprated by inflation. And that's pretty significant at the moment because inflation's very high.
Yeah.
Well, you're certainly high in the first year following the announcement. I mean,
yeah.
if it's, I don't know what index to
no
believe,
RPI or whatever, but they're all pretty high. I mean, even now it's 7% or something, isn't it? Which is significant.
Exactly. Thank you very much.
Okay, well, that's interesting, just to keep us in touch with that. Another frequent subject for discussion on these occasions is cost budgeting. A little bit to say on that, Alex?
Yeah, so there's been this Civil Justice Council report on cost budgeting, which, you know, essentially retains cost budgeting, thinks it's generally a good thing, but says that one size shouldn't fit all, so you should adjust it depending on the case. It's all, to be honest, a bit vague at this stage. You know, we'll have to see what the proposals are in relation to budgeting for different cases and different types of cases. I mean, you know, it sort of goes back to the hourly rates. There's been an interesting debate about, I mean, Lord Justice, well, Lord Leggett, as he is now, Mr. Justice Leggett said back in 2015 in Kazakhstan, Ghazi and Zunas, that essentially all that you're getting is the lowest amount which it could reasonably have been expected to spend in order to have their case conducted and presented proficiently. There's been a decision for actually 2021 by Peter MacDonald Eggers QC, as he then was in Discovery Land and Axis Specialty Europe, saying, well, I agree with all that, apart from the lowest amount. It doesn't seem to me to be right, because budgeting is supposed to be within a range of reasonable amounts. And why should I go for the lowest amount? I can go for slightly higher than the lowest amount, as long as it's within the reasonable range. And so, you know, that debate is out there, unfortunately, for Mr. Eggers, MacDonald Eggers. Lord Leggett is now in the Supreme Court, so his words may carry more weight. But certainly there is that debate to be had. There's a conflict between what defendants, paying parties often cite from Leggett in Kazakhstan, Ghazi, and, you know, what the budgeting provisions are, which that they should be in a reasonable range. Why should it be at the bottom of that reasonable range? So there's that's out there. There's also this decision in Ras Al Khaimah Investment Authority and Azima, where I mean, it was obviously a huge case. So I mean, you know, the judgment sets out that the spending in relation to the case was in relation to an 8 to 10 week trial. The budget was £21.5 million, including an estimated future cost of £12.3 million, etc. And the judge queried as to how he could possibly deal with budgeting in such a case. How could he come to views? It was then pointed out to him, well, he'd made an order for cost budgeting to apply to this case, so he then had to do the best. But he did slightly throw up his hands in despair as to how he's possibly going to do this exercise. It is very difficult in those kinds of cases. In my experience, it makes sense to do it in stages, to have budgeting till the next stage, etc. You know, that can work quite effectively. So you're not looking right through to try, you're looking right through to the next CMC or whatever. That certainly can work. And the other issue that was raised by this Civil Justice Council report was whether you, I'm always conscious of the fact that I might be quoting Chris Martin about his break with Gwyneth Paltrow, conscious uncoupling, whether you uncouple cost management from case management so that you don't have the two at the same time. You know, clearly in the run-of-the-mill case, budgeting is obviously going to be affected by the fixed recoverable costs. So it doesn't apply now to £100,000 or less, but anything between £100,000 and 10 million is ostensibly within the budgeting regime. And indeed, of course, there's a discretion over 10 million to apply the cost budgeting regime in relation to it. So sorry, I've slightly lost my train of thought there, but anyway, there we go. So there are, you know, there are things.
The thought of Gwyneth Paltrow was too much for him.
I know, yeah, exactly. No, you're quite right. It was conscious uncoupling, and that absolutely does make sense. I mean, certainly, I remember doing the Mau Mau claims against Nick Bacon, where we had, 40,000 claimants, and we tried to do the case management at the same time as the cost management. But of course, the judge then made case management directions, which neither party was expecting, or somewhere in between or whatever. And the cost budgets had not been geared towards that kind of direction. And so everyone was trying to do it on the back of a fag packet outside court while the judge was waiting for us. It didn't work at all. So once we split the two, it made much more sense so that you'd had a case management and then 3-4 weeks later you had a cost management hearing. That worked much more effectively. And in the big cases, I think that is a way forward. And certainly the CJC were very open to that idea. I don't
I'd have to do something about incurred costs there, wouldn't you? Make some provision.
Yeah, exactly. It's got to be dealt with. When do you say the incurred costs are up to? You could, I suppose, I mean, Andy, I'm sure you'll have views on this. You could say it was up to the case management conference, and then everything else is notionally future, even though it's, there's a bit of past there.
Absolutely. Yeah, that sort of approach I think would possibly work. I think the way you've just explained how that uncoupling could work is quite reassuring, because it's not saying we want there to be actually a stronger connection between case management and cost management in terms of the extent to which that was originally mooted was so that judges would always have the cost implications of case management decisions available to them and should influence proportionate case management. Now, this then is a little bit like a dog chasing its own tail. But certainly, if for no other reason than in large cases with lots of money, cost budgeting should be done carefully. And if it's squeezed at the tail end of a case management hearing, where people have luxuriated over important aspects of basically trying to coordinate diaries a lot of the time and saying, well, is it going to be 3 weeks or 2 weeks, or can we do it that date or that date? And then you're suddenly dealing with 10 or 12 million pounds of cost in 5 minutes. So it doesn't really, that seems like a very rough piece of justice to me.
Yeah, no, it does, absolutely. And it raises the point that you've got to have a system, I think, even if you do consciously uncouple, you've got to have a system where the judge at the case management hearing has budgets of some kind, for the very point that you say, Andy, that he's supposed to be tailoring his case management to the cost implications of it. So he or she would have to have some sort of budget at that time, but perhaps it could just be updated as a result of the case management decisions, and that so that the two are in step, but they're just separated by date.
The other point I was going to make was on doing it in stages, which has been, as you say, successful in certain group actions where some form of cost management has been around for probably longer, actually, even when it was in draft form or inherent powers. But it occurred to me that if there was to be any changes to the way cost budgeting was done, it might start to be useful to look more at chronological stages than overlapping phases when it came to constructing budgets.
Yes.
Because that would certainly help you with staging. And although I get a bit queasy thinking we should be borrowing anything from the fixed cost regime, but the fact that they've gone to stages is something that I think is we might be able to nick something from that actually could be quite practical and quite useful in budgeting and actually make more sense to some people.
No, absolutely. And the reality is that the phases are generally, apart from kind of pre-action or whatever, they're not neatly it's over. I've done my pleadings or my statements of case, therefore I'll move on to the next thing. I mean, what about amendments to pleadings and further documents, etc., etc. So it's not as neat as saying, well, we'll do this and this phase, and then we'll do but it's by date form. It's certainly it's worked well in group actions. I don't see why it shouldn't work well in you're talking about big cases here. I don't think you need to do it in mill cases, but in big single cases, I think it can work well as well.
Great, thank you.
Okay, I think that's been a very helpful review of the situation in relation to budgeting and possible changes that might be made. It's a very quick point we've got, which is more information than anything else, about the conversion of costs which were not billed in sterling. Important not only for the technical point involved, but also because a theme which runs through this podcast today is you have to get your retainer right. You have to tell your clients about things that might affect them that at the moment you beginning of the litigation, you don't know. So a quick word on costs not billed in sterling, Alex.
Yeah, no, well, actually, I think probably Andy knows more about this than me, because you've certainly dealt with this, isn't it? I mean, the principle from the Supreme Court is that the date for conversion or for the sums paid by the receiving parties is the date of payment and not the date that the bill was filed, and that's the decision they came to. But Andy, I'm sure you can speak more eloquently about it than I.
No, I've got a headache. Suddenly. Yeah, this came up, and it was useful to have it tested and aired before a senior cost judge, Colin Leonard, in the McCullough case in the Supreme Court. But it was, I think, of general application that he reiterated that his best interpretation of the law was that if you are going to have assessments in sterling when clients have been billed in other currencies, maybe just one other currency or maybe a mixture of the two, who knows, all's possible, that it is probably right that the assessment should proceed in sterling, because this is where we are. Otherwise you're asking a cost judge to make mini calculations, micro calculations, to assess the reasonable value of every item that he's looking at. But the precise conversion should take place of when the own client bill was paid and what the conversion rate was then. All well and good, except it does make detailed assessment pretty complex, to the extent that although you can run it in the background, because you can run reports in different ways and in different form, you're then almost a little bit like dealing with the niceties of general Byrne with indemnity principle stuff. You're almost having to chop the bill up, at least for one view, by client billing periods. And there could be, therefore, as many hourly rates per person for the same euro value or US dollar value as there were interim bills, which could have been monthly over the course of a 4-year case, which produces a lot of data for slightly questionable value, I would say, in terms of an assessment. And therefore, I would say that the law is clear, but in those cases where some sensible accommodation can be reached between opposing parties, that it would be in all parties' interest to try and cut through some of that and just take a pragmatic view as to perhaps an average for a period or so on and so forth. And there would be a roundabouts and swings approach, and nobody's trying to get an particular advantage out of it. But I must also say, from my point of view, well, the law is the law, but if you pare it back to basics, on the basis that the client should be restored to the position they were had they not had to incur these costs, then should not the exchange rate be the one that applies at the date of assessment, so they can get back the right number of euros, or that are equivalent to the proportion of their costs that they've recovered at today's rate?
Yeah, I mean, it would certainly be.
I know.
No, I agree. Well, it would certainly be a lot simpler. I agree.
Yeah. So that's
the idea of the parties going away to agree among themselves was one suggested by Master Leonard, having come to this conclusion, which of course is great in cases where people are being sensible. But there are so many cases we all know where people aren't sensible, and then you do end up with an amazing mishmash of rates.
Yeah. Yeah, exactly. Yes, I mean, it's something that I think is probably worth us airing here, because not just because it's happened recently, but actually on a fairly regular basis, we're often asked by clients what the best way to approach it is, and it may be in the context of a relatively confined statement of costs for an interim application or something like that, But it adds another layer, when you're trying to do something quick and efficient sort of stuff that is also clearly set out.
Yeah, I mean, I've seen statements of costs for interim hearings which are in dollars, for instance.
Yeah.
Which I mean, I think that's problematic, but yeah, it does happen. So there's a diversity of practice.
Yeah, no, there is indeed. Yeah.
But I think even if the rule is as stated by Master Leonard, I seem to remember a dictum in a very old case, even before I was in practice, saying something like taxation, as it then was, is made up of much sensible approximation. And one would hope that if push came to shove, a cost judge would actually be able to do something along those lines, rather than have to allow an amazingly complex bill for perhaps not a huge amount of money.
No, exactly. I mean, and that's the paradox. You know, so many things we do, it seems to be like dancing on the head of a pin, and then there are, you know, completely reliable jurisdictional points where a cost judge could say, yes, I can see you've gone over budget and I can see why, but I'm just going to pin you to it. Or yes, you've done a bit more and I can see why you did, and that came by surprise. I'll give you 10% more. There's nothing wrong with that, is there?
Not at all. No, we're all agreed on that.
Okay, well, we mentioned from time to time solicitor and client disputes, and the question I was really going to ask Alex is, are solicitors now safe from people like checkmylegalfees.com?
So they've been under attack, checkmylegalfees.com, by the master of the rolls, Geoffrey Voss, who well, he's got the Solicitors Act 1974 in his target, as well as checkmylegalfees.com. But checkmylegalfees.com have cleverly exploited to date the principle that we've talked a number of times about shortfalls in recovery from the other side. In that context, it was the old personal injury fixed recoverable cost regime, where literally cases going to Court of Appeal about, I think, £232 in the case of Belsner, which was the cause célèbre, and in the related case of Karazits, it was I think it was £131 or whatever, and so they were generating huge amounts of fees about a very small shortfall, and Geoffrey Voss didn't like it at all. I understand that checkmylegalfees.com has survived the onslaught from the master of the rolls so far. They've been bought by Richard Slade, I think. I understand. Richard Slade is a firm of solicitors that is very active in the cost field, which is, of course, to be praised to the highest. So we'll see if they live to fight another day. But there clearly is a market out there for some of the reasons we've said about shortfalls for solicitors' bills to be challenged, and Belsner underlines that, and indeed there are other cases out there where Geoffrey Voss has been very critical of both the regime, the Solicitors Act itself, which he regards as completely out of date, and it is true that the Solicitors Act 1974 is heavily based on, well, it goes back, in fact, to 1729, and I think the Attorneys Act of 1729, but most obviously the Solicitors Act of 1843, which is in very similar terms, so it hasn't moved on at all, or not much since 1843. And Geoffrey Voss thinks that it's completely out of step in terms of the consumer protection legislation with which we are so familiar with these days, which wasn't really the case in 1974. That the requirements of the Solicitors Act are the division, for instance, between contentious and non-contentious business, which goes right through the Part 3 of the Solicitors Act, it is a mess. Belsner underlined that because all the pre-action protocol litigation that is dealt with in the fixed cost regime is defined as non-contentious business, even though it's clearly contentious in the kind of sort of common parlance. So that is a mess, and that needs to be sorted out, and I'm sure that Geoffrey Voss is right about that. The difficulty is how you're going to do that, because we talked about the government acting on PACCAR. Will they do anything about the Solicitors Act? It clearly needs updating in relation to that. The other factors are that it is very technical. We've all benefited from technical arguments about whether the solicitor has rendered a Solicitors Act statute bill, or as Geoffrey Voss likes to call it, a statutory bill or not, and what the requirements are. The present senior cost judge has been very critical of the fact we spend days arguing about whether it's an interim statute bill rather than getting on and assessing the bill. So that is out there as an issue, and also the obligation. There is no obligation to inform the client that time is running against them when they serve a statute bill. And the cost judges developed a kind of line of authority which suggested that if you didn't tell the client that they had a certain amount of time to challenge their bill, then it wasn't a statute bill, and the solicitor lost out as a result of that. But the higher courts have made it quite clear, and it's clear on the legislation, there is no such obligation to tell the client, and therefore it can be a statute bill, even if the client doesn't know that time is running against them and they haven't gone and looked up Section 70 of the Solicitors Act themselves, but they haven't been told by their solicitor that is so. So, there are a number of difficulties with the current Solicitors Act. Whether it will be changed, as I say, is well, it's not obvious that it will be. If you apply the same test, namely, will the government benefit from updating the Solicitors Act to make it fit for purpose in 2023, the answer is not obvious that it's in the government's interest to do it. But we'll have to see. Perhaps particularly in the context of the present government coming up to an election, perhaps not wanting to spend a lot of time on the definition of interim statute bills.
The suggestion of the Master Rolls to deal with these disputes over relatively small amounts of money was that you should go to the legal ombudsman instead.
Yeah.
We at Practico took the trouble of downloading the latest annual report and wading through it. We couldn't find any reference to an sudden increase in cases as a result of this decision of the Master Rolls. We just got totally bogged down in key performance indicators and other fascinating material, but there was nothing about substantive content in the report. So it's hard to tell whether, in fact, anyone's taken up that particular suggestion, and if so, with what result, because we talked about the technical issues involved in some of these cases. Would the staff of the Legal Ombudsman Service be up to dealing with those issues? They're pretty complex for anyone to deal with.
And the Ombudsman Service is always under huge pressure, isn't it? They're always behind. There are always long time delays, etc., etc. So yeah. How they're supposed to deal with an influx of these kind of cases, which presumably, as we were saying earlier, may grow significantly with fixed recoverable costs for pretty much all cases under £100,000. That is covering a huge percentage of litigation in this country, where you're going to get less off the other side. So the potential for challenging your solicitor's bill for the shortfall is ever greater. I suspect that unless you invested a lot in the legal service ombudsman, it just ain't going to happen.
Well, I can tell you they have managed to. I've read the report. They have managed to get the backlog down, but I think it might be going up again if this suggestion is taken seriously.
Yes.
Anyway, finally, just to
sorry, Jerry. Just wanted to say, as a finish to that, it is a theme that we talked about. You must get your retainer letters right, and it's amazing how many major firms are not getting their retainer letters, and I see it all the time, both for the client and for the firm themselves. You've got to make it clear that bills are self-contained and complete for their period. If you don't do that, it's not an interim statute bill, and you can't then rely on it. And so, the message is, obviously, you need to go out to, people like us to get your retainer letters sorted. But you do. It is remarkable, as I say. There are magic circle firms are not doing this properly. It isn't rocket science. Clearly it needs cost counsel to deal with it, it's that complicated, but it just needs attention, because I think people aren't looking at these things, and then they come a cropper when a difficult client challenges them and they realize, ouch, our standard documentation just isn't up to scratch.
And we're not there talking in many cases about the legal ombudsman. We're very often talking about very large amounts of fees.
Absolutely. Yeah,
particularly in ongoing major litigation.
Yeah,
I don't think they
finally then on a light. Sorry,
I don't think they can rely on us launching a checkmylegalfees.com fees.com to come to the rescue. We'll duck out of that one.
We should be challenging their fees. Check my
Exactly, yeah, that's right.
There's a new industry there.
New industry there.
Yeah.
But I've got to conclude this session with an embarrassing question to Alex. Did you prepare all of your talk using ChatGPT?
It's a very good question. I have to say that I don't have the technical ability to use ChatGPT, so I'm innocent on the basis that I'm ignorant. But it is a very interesting question, and you know, Andy and I know Lord Justice Burrs, having dealt with him over the electronic bill. He has caused quite some controversy by saying at a conference that in a recent judgment he gave, which was an intellectual property case, and he is, you know, an intellectual property. He was a practitioner. He is very skilled in this area. He used ChatGPT to summarize the law, and he said that it was jolly useful, I think was the quote. So I interestingly, I met one of the other people that's on the CJC with him on this report that we were talking about earlier about cost budgeting, etc. Mrs. Justice Joanna Smith, and she was very touchy about this. She clearly didn't think that it was the wisest thing for Colin Burrs to have said in terms of encouraging people out there to use AI to get legal advice. And it is true that Colin Burrs, as we know, is very techie and very good, and he was dealing with a subject that he knew well. So, you know, he wasn't just simply deploying something that somebody else had produced. I think, you know, as I understand AI, it has significant limitations in terms of legal advice. It effectively just searches what's out there and regurgitates it and gives a summary of it. So it's totally dependent on what's out there. You just don't know what the source is that it's got from it. And it also has this ability to make up stuff. So it might say, you know, an accurate statement of the law, but then cite two cases from the 19th century. When you then go and look up the cases, they don't exist. They've simply been, it's a figment of the AI's imagination. So I think it's pretty unwise if you start doing it, at least without checking very carefully. I did talk to a university law professor about this, and he was obviously very alive to the fact that students might be producing essays which were based on AI, and he'd spotted some where there was obvious repetition, so much repetition that it couldn't just be a useless student. It was clearly a machine that had produced this, and some where the cases which he looked up were fake. They just didn't exist. So it's you know, it is obviously going to be an increasing feature, but I think the message from the judiciary, I don't think Colin Burrs was entirely on message in what he says. I think they're going to try play this down. You know, it feeds into it to another thing that I heard recently about an allegation that was made by some organization in Ireland that the Irish judges were all using Wikipedia in their judgments. And so the Irish judges took this very seriously and then commissioned a proper report into, you know, scientifically, statistically working out what was in Wikipedia about certain things and, you know, how much of that was in there. And, you know, it exonerated them. Apparently they weren't using Wikipedia. Didn't seem to be the worst thing. I think I've probably used Wikipedia just as background information on somebody without actually getting legal advice. But you know, it is out there, and ChatGPT perhaps could have some sort of role, but it's very limited. I think if people are using it to do drafting their skeleton arguments and or their judgments without knowing what they're doing, without knowing the area of law, you know, obviously Colin Burrs was just testing it to see whether it worked or not. I think it's very dangerous.
I mean, to be fair to him, he did stress very much that it was an area he knew very well, and I'm sure, you know, you, Alex, could actually use it for a cost case, and you'd know whether it was on the right track or not. But interesting and possibly frightening developments, because how do you check when people have got skeleton arguments and all the rest of it? Are we getting to get to the point where you can't rely upon what counsel has submitted because it is based on something which is not well-founded? And is that going to lead to a whole string of referrals to bar council, etc.? I mean, it's, you know, the implications are infinite. But let's not worry about things like that. Let's look on the bright side, and just like to stop by thanking you very much, Alex, for your really interesting contribution today. And so we look forward to seeing you again before very long. We look forward to seeing everyone else on our next Cost Pod.
Thank you very much, Jeremy and Andy.
Thank you.